prosecutor, including the complexity of the matter, preparation for trial, availability of suitably qualified prosecutors, and the financial prejudice to the state. See Mr. Downer's answering affidavit, paragraphs 82 through to 93. It is worth mentioning that except for reiterating that Mr. Downer is not indispensable, Mr. Zuma did not deal with any of the above reasons in his replying affidavit. See Mr. Zuma's replying affidavit, paragraphs 75 through to 79. To conclude, I am satisfied that there is merit in the submission that the grounds advanced by Mr. Zuma were sufficiently dealt with in previous litigation. In his own words, Mr. Zuma stated in paragraph 160 of his founding affidavit that he is aware that some of his atmospheric issues had already been dealt with in previous litigation, albeit in pursuit of different causes of action. He concluded by stating, and I quote, "Whichever way they may have been construed in such previous litigation, they are now invoked merely to demonstrate that the overall atmosphere is sufficiently poisoned and too toxic to permit for any fair trial if Mr. Downer is or remains a prosecutor in the public prosecution brought against me." Having considered all the grounds relied upon by Mr. Zuma, both individually and cumulatively, I was unable to conclude that Mr. Zuma's right to a fair trial would be violated if Mr. Downer remained the prosecutor in the matter. Those are the reasons for the order I granted on 20 March 2024.
My Lord, in anticipation of what happens now, my learned friends and I for the state have been in discussion as to a timetable, because we're now proceeding for the actual application for leave to appeal against the second removal application, against the dismissal of that application. So, my Lord, for your Lordship's convenience, I have typed up a timetable, which you could hand up. Sorry, could you? And this takes into account the availability of counsel for all the parties. My Lord, if we could start off with the dates for the hearing, given the availability of counsel for Mr. Zuma and counsel for the state, we propose that...
Is this the date for the hearing of the application for leave to appeal?
The actual hearing, yeah, the last paragraph there. It's 25, 26 or 27 November and 4, 5 or 6
I won't be
December.
available. I won't be available.
My Lord?
I won't be available then.
Or the 4th, 5th and 6th of December.
I'm not going to be available during the course of this year for the remainder of the...
You're not available?
I'm only going to be available in January next year.
In January of next year?
Yes.
My Lord, I'm sure that we haven't discussed that amongst council, but if your Lordship could give us a date, then we would, I'm sure, make a plan. But prior to that, my Lord, we also did discuss a timetable for the exchange of papers, and I think we could stick to that anyway.
Yes.
So that we could get that behind us and get ready for the actual application. And that is Mr. Zuma's supplementary application for leave to appeal based on your Lordship's further reasons, right. The 4th of October 2024. The date for our supplementary answer, that is the 11th of October 2024. Right. Mr. Zuma's heads of argument, the 25th of October 2024, and the state's heads of argument, the 1st of November 2024. I've indicated that date might be movable depending on which counsel is available. My learned friends for Mr. Zuma have agreed that might be moved on a week, so it might be the 8th of November, depending on counsel. It's not going to make any difference given the date that your Lordship proposes to give in January.
Okay.
Right. My Lord, we could then discuss the date for the hearing once we hear from the court. My Lord, there is just the further issue that this court has reserved the dates next year of the second and third terms, starting in April and running on then until basically the end of the trial.
Yes.
and the availability of the court.
Yes, those dates remain reserved.
Remain reserved, yes. That is, so, my Lord, we will certainly argue that whatever the outcome of any application in January, the state will argue, and if necessary, we'll argue it formally and properly before your Lordship, that those dates in April must remain and the trial must start on those dates, whatever the status of any appeal processes might be going forward. Because no matter what your Lordship decides in January, on the date which the court will then set, obviously, if it goes against my learned friends, then for number one, accused number one, they will take it further up the line, in accordance with what we say is Stalingrad, and that this cannot be allowed to continue. And so we will argue that the trial we must all be prepared, our diaries must be open, briefs must be properly issued, preparations must be so that on the date in October, I think it's in April, I think it's the 15th of April, it's in the draft order we previously gave to your Lordship. It's the 14th of April, and the following terms. We will all be ready for trial. The state witnesses will be briefed, the police will be available, the court will be available, and my learned friends, certainly for accused number two, have indicated they're available. Mr. Mpofu, who's not here today, but he has indicated he is available on those dates. And we must make it now clear that we cannot simply carry on moving the trial on to accommodate a long series of appeals, which take sometimes years, up to the SC and the Constitutional Court. So we will argue. And we're happy with that. Your Lordship keeps those dates reserved under those conditions. May it please the Court, my Lord.
Okay. Can you prepare a draft order accommodating dates mentioned in paragraphs 1.1, 1.2, 1.3, and 1.5, and then leave a date open for paragraph 1.5? That is the date of the hearing. Also, I'm going to adjourn for a moment and discuss a date with the Judge President, because I don't even have a roster for next year.
As it pleases the Court.
Right. Mr. Buthelezi?
The Court pleases. Thank you, Madam. With the exception of the submissions on the dates, we obviously now have to take exception to the proposal that the dates for next year, April, remain reserved, simply because of the absurdity of the proposal. If already we can anticipate that we will argue the application for leave to appeal, not the leave to appeal, application for leave to appeal, in the first quarter of next year. What purpose is served if we can then enroll a matter that is, for all intents and purposes, from what we can anticipate, will still be the subject of an appeal come April next year? And for them to say, I mean, so casually, glibly, Stalingrad, well, that we take exception to that, because we are exercising our rights. So it's no creation of ours that this application is now going to be heard at this time of the year. Judgment was granted in March. Okay, so we never created that circumstance that causes the reasons to be given in September. So I think it will be prejudicial to the court to keep blocking those dates when we know now, as a matter of fact, we may have those as holding dates, but to block out 2 terms is prejudicial to counsel, because Mr. Dana can't explain how it could happen that while the matter is being appealed, whether that leave to appeal is granted or denied, the appeal avenues that exist in as far as petitioning the SCA and petitioning further make it unfeasible that we would sit here with good mind and good conscience and assert that we're going to start the trial at the start of April next year. That's not pragmatic, and that's not possible. So I'm not too sure whether the court can be cornered into putting that in an order. As we previously did it with your brother, Justice Kuhn, we would have some dates, because we could not postpone the matter sine die, to come back and postpone the matter or update the courts. And then only once that certainty is ascertained can we then go back and say, because there's counsel for the second accused and ourselves as well, involved in other matters, to now have in September this year a commitment that says we're not available from the second term, when we already know that yourself, my lord, is not going to be available at the end of this year to hear this appeal. So we're already in Q1 of next year. So that's the only point, my lord. Other than that, we're okay. We just, in as far as the date of next year is concerned, our proposal is the second week of February for the hearing of the application for leave to appeal. Because
January, Mr. January, Mr.
my leaders, I'd have to
date, Mr. Buthelezi.
Well, end of January, my lord.
Right.
We're in your lordship's hands. We're in your lordship's hands. We were just putting the proposal on the table. Other than that, everything else was by mutual agreement, madam.
All right.
Thank you.
That's fine. All right. We'll stand adjourned, and I just want to consult the Judge President with regards to the dates that are available, because we don't even have a roster for next year. Court adjourns.